Laura.
Good afternoon. Welcome to RAM Symposium. This hour we feature working with industry, information for preparing proposals, and talking with industry sponsors. I am Mara Link, your moderator for this session. Please note that today's presentation is being recorded. This presentation will last about 60 minutes. All participants are currently muted. During interactive portions, though, we invite you to unmute and use video as you feel comfortable. If you have a question or comments, please use the chat feature or raise your hand. We will be monitoring the chat box throughout the presentation. Closed captioning is available under the Teams option menu. Please make note of the post-evaluation survey link posted in the chat and be sure to complete the survey at the end of today's presentation. It is my pleasure to introduce our presenters for today, Bill Mosley, Tricia Sothergill, and Grant Kaplan.
This is not here in person, she's here virtually.
Just tell me when you want.
Okay, may as well go ahead. Yep. So I wanted to start off with a couple of quotes from an organization called UIDP, which stands for University Industry Demonstration Partnership. For those of you who have been in research administration for a while, you may recognize the DP part of that from Federal Demonstration Partnership. UIDP is a group that, like FDP, got together to try to facilitate industry and universities working together. But I thought they put together a contract accord and basically just outlines sort of positions for contracts for research between industry and universities. I liked this quote and the next slide, which will be another quote. So from an industry perspective, why do they even want to engage with universities, and then why universities might want to engage with them, and the sort of approach that each entity takes to an agreement. So industry could want to do research or fund research for corporate responsibility purposes, like just philanthropy. They want to help the community. Or the last two parts of that first sentence, for some commercial reason. And usually it's the last two rather than the first one, but they have all kinds of motives. And they need to do it to further their business. So they're in it for the money in some ways. Next slide. Universities, on the other hand, we're sort of in it for the money as well, but it also helps us with supporting students, making partnerships, further research down the road, those sorts of things. What we'd like to get at with you all today are those four objectives, but I would say sort of the overall objective is we want to pull back the curtain a bit for faculty and department research administrators as to what it is that OSP does and why it matters, and how faculty and department research administrators can kind of help us make the process of working with industry go more smoothly. So we'll talk about the differences between industry agreements. Tricia will talk a little bit about budgeting for industry. Grant will do an interactive portion on working through terms and conditions and some agreements. So we'll look at some actual agreements that have been put in place for CSU and industry. And then just sort of sum up by what can we do to talk with industry. So the key differences between industry contracts and federal assistance agreements. It's not an NSF grant. So grants and cooperative agreements, or assistance agreements as we call them, are really flexible sorts of agreements that we get from the federal government. And they're designed to provide funding to the university for a public purpose. And that public purpose can be things like creating and disseminating new knowledge to everybody. So we're not going to be restricted in who can work on the project or whether we can publish or not. And it lets the academic side drive the questions that are being asked. So the PI comes up with the scope of work, the proposal puts it out there. And they have to work toward that scope of work, but there's not an emphasis on the delivery of specific things other than, did you carry out the research project that you were proposing to do? Federal government allows us to own any IP that gets generated as a part of the project. The government keeps the ability to use it and could pull it back if we weren't using it, but they felt that it was useful, and some other entity needed to be able to commercialize it. So they keep those rights, but we get to continue owning all of the IP that we generate. And of course, as I've already said, we can publish. The other hand, you have contracts where the basic purpose is much more rigid. It's a binding agreement between somebody who's buying something and somebody who's providing something. We're usually providing services in the form of research here. And something of consideration, money, changes hands as a result of that agreement and the performance of that agreement. The scope of work is usually conceived of by the party that's issuing the contract. So industry comes up with what they want or need done. Heavy emphasis on delivery of those specific results. Usually a scope of work is much more detailed and has a task and a deliverable that is supposed to be provided, not just an annual report and a final report. Intellectual property. The industry tends to want to have control of anything that would be commercially valuable for them so that they have commercial advantage coming out of the agreement. And they want to be able to control the information. So IP and data can be two different things, or at least considered in different ways in these contract agreements. IP could be a patent, or data could be just the data from running tests on samples that the company provides us and giving them back that data. So they may want to own all of that data. And so next few slides, we're going to talk about sort of why do these differences matter to a university in the context of the mission of a university. So our mission is the free and open pursuit of new knowledge and its dissemination, contributing to the general good of society. As part of that, we educate the next generation of researchers. The university's reputation and viability as an institution, a social institution, is really based on faculty and students being able to publish the results of their research, copyright it, and patent it if there's something patent. University researchers and the university itself share in any revenue from licensing those inventions to companies that are interested in trying to turn it into a commercialized product. And then lastly, as a state entity, we're responsible for using taxpayer resources to support that mission, all of those things as part of our mission. So grant terms and conditions, you can probably see, fairly easily fit with that mission, right? We're allowed to publish. They even require us to share the data the results of the research so that other people can recreate that same research and validate it. They don't restrict who can participate in the research. So there's no restriction on foreign nationals participating in the research, for instance. And they provide us ownership of the intellectual property. In contrast, industry contract terms tend to be trickier to negotiate because that commercial liability that industry wants when they enter into a negotiation or some set of research by a university. Publishing it may take away the secrecy that they might have around whatever the research area is that gives them a competitive advantage. Same with controlling the intellectual property. Industry is going to want to know that they can use intellectual property that comes out of an agreement. That doesn't mean that they have to automatically own it. And there are ways that we can negotiate terms to get to something that's good for both industry and the university, but it's not the set university owns it, which we would prefer. At least not always that. And then of course, the business practice. Those people who are looking for value in what the company is buying can try to nickel and dime us, basically. Challenging things about industry contract terms. I've already sort of gone over lots of these, but publications can specifically hurt graduate students. If a graduate student's working on a project and they can't publish the results of the research that's funded by an industry, they can't complete their thesis or dissertation and can't graduate. So we have to be careful that when we get a publication restriction in an industry agreement, it's not going to hurt grad students, especially, and frankly, same for new faculty who need to publish or perish. So we don't want to have somebody entering into lots of industry agreements as a brand new faculty member that keep them from being able to publish to get their reputation out there. The same with the data ownership. If they say in an agreement, we own all of the data resulting from this research, that means they own it and we don't have the ability to publish. Number 3, intellectual property ownership. Again, if they own the IP that's generated, it's a problem for the university, at least on its face. Work for private benefit, which would be anything that restricts our ability to publish or otherwise not meet the public purpose of a university, can jeopardize CSU's tax exempt status, especially if there are 2 areas: UBIT, unrelated business income tax, and tax exempt bonds. So UBIT is sort of, I need to look to the lawyer in the room to explain those, but UBIT would be for the whole institution, right? It's any work that the university would do that's for private benefit could be considered unrelated business income to the university and be taxed again. Tax exempt bonds issue would come into play if the work was being done in a facility that was financed by tax exempt bonds. And some of our buildings or renovations to buildings are financed that way.
Most of our building in the last 5-10 years have been bonded buildings through the state.
So if faculty are working in new buildings,
Yeah.
we may need to look at it carefully. And then the last one, just the industry needs to be able to access the IP, can bring in background IP. So if a faculty member is needing to use something that they created on another project as part of the deliverable on the new project, but that background IP is already licensed to somebody else, we can run into issues there. So we need to be sure that as we're working through agreements with industry, that we and the faculty and the industry partner understand what if any background IP there is and what the foreground IP that would conceivably be generated into the project is.
So why do we do this? Based on everything we just heard, why do we even engage with industry? There are reasons. There are ways that you can get to a middle ground on things like publication and how we use the intellectual property that still fit within that mission, right? You know, you can still publish, you can still further your career, you can still practice the discoveries that you've created in a particular way that still allows knowledge to move forward, but also still benefits the company and their commercial interests. You know, most graduate students don't go into academia, they go into business. And so it's important as part of our mission to educate them, as Bill said, to prepare them to work in industry. So working with industry gives them the skill set and interaction to get hired, and also just to be the next generation of scientists that work with industry. A lot of times also, you know, you'll have a postdoc or a graduate student in a lab go work for a company, and then that company re-engages CSU in similar research going forward. So it's not like a company is coming in and just sucking the lifeblood out of the university to do research. There can be ways that the Venn diagram overlaps for those things. Again, it's that access to talent and they want to come work with us. And if you want to really be on the cutting edge of things, you know, universities do a lot of great basic research, some great applied research, but you know, the companies making money and pushing the envelope are really also where we want to be to get our best people in front of the best employers. And so there are certainly other universities, there's a whole spectrum of approaches to this. And there's certainly some universities who say, you know, we want to do this work for the sole purpose of getting our people hired. Like that's what we want, and we want to be known. We want the reputation of being the best in the country or the world at this thing. And that notoriety is worth it in some ways to the leadership and to the institution. So it's not as bad as it sounds, just right off the bat.
Well, hello, everyone. We're kind of going in. Can you hear me? Everything okay? Give me a thumbs up, Bill.
Yes.
Oh, yeah. All right. We're in business. So now we're going to get into some of the nuts and bolts of working with industry. And one of the big parts is budgeting for industry. It is a little bit different. So just a quick overview of some basic requirements. Next slide, please. So part of what we really want to make sure is that we do have these principles of cost estimation, that we have them apply to the budget and our overarching budgeting methods, is that the university cannot provide a better deal to the private industry than we do to the federal government. As well as CSU cannot use public resources for private benefit and cannot unfairly compete with business by undercutting price for the same services. While we may be having the same services as private companies, we need to make sure that our costs are based on our true costs, not on trying to get the business at $5 less a sample than our competitor would have. Next slide, please. So one of the big questions is, what is it that we need to consider when we're developing our budgets for industry proposals? Number one, all costs. Every bit of the project cost should be paid by the sponsor. We should not be cost sharing if industry is funding. And when I say that, I'm not counting federal pass-through where there may be cost share required. I'm talking if the industry, the actual company, is funding the project. And so one other item that we want to have is PI effort needs to be included. Again, that could be implied cost share if it's not. Let's see, this is one that I have seen many times, is that our full indirect or F&A rate needs to be applied, and it needs to be applied to total direct cost. When we're working with industry, F&A waivers are not allowed and will not be considered for for-profit sponsors. I've had several instances where the proposal will get all the way through to RA review, and there's an F&A waiver, and then it has to go back to the beginning and needs to be revised. And that causes a lot of stress for a lot of people. So we want to avoid that. And this is the next one that is sometimes confusing is we don't want to disclose what our indirect cost rate is. We want to present a fully burdened budget, and that is where all of our costs are in each line item. So it would be our direct cost as well as our indirect would be in each line. And industry, they do have their own overhead rates, and it's built into every single one of their costs. And while many people in industry will swear up and down they don't have an overhead cost, they do. It is just hidden inside of their costs, and they don't see it as easily as you can when we have our F&A rate separately. So we definitely want to make sure we have those fully burdened budgets. There's great FAQs on the OSP website, which is linked down here. And I highly encourage all of you to read those for some more useful information. And in the next slide, we're going to see a sample budget. Okay, so here's our sample internal budget that I made up. Very simple budget. And so I showed, you can't see my cursor as I'm hovering over everything. But however, we have the PI effort, which is great, CAM the RAM. And we have the fringe in there. We've got some travel, some materials and supplies, some other direct costs. And then we see our F&A is in there. So we have that unburdened, which is what would match in KR. And then we also have the last column, which is our burden budget, which is what we would want to show the sponsor so that they would see our actual total project costs, not have it split out between direct and indirect. And on the next slide, it shows what would actually go to the sponsor. We would not want to show the unburdened total or the lines for F&A. And I recommend that whenever things are submitted to sponsors, that it go as a PDF and that you can hide those columns in Excel and then just save it as a PDF. And so there's no extra math in there. You can just have it all and then hide it, PDF it, and then you're set to go. And that is our section on sponsor budget. So I hope everyone remembers the big thing is to have that burden budget in there and submit it so that we don't have sponsors that come back and are all, we don't want to pay that much. And then we can get into some issues. So thank you.
Sometimes sponsors will ask to see the unburdened budget, but better to start with this. If they want to fund the project, if we presented a burdened budget to them, they're not going to not fund it just because of that. So.
And I will say, just throwing it out there, that there is a burdened budget, fully burdened budget in KRPD that can be selected from the print screens. So I apologize, I do not know which line item, which budget it is, but there is one that is a fully burdened one from KRPD, so you don't even necessarily have to do the math.
Yep. Thanks.
At this point, do a quick run through based on time and everything else, and leave a little time if people have questions to go through a few examples of the actual terms and conditions in some of these agreements. It used to, in one of our previous drafts, it said the good, the bad, and the ugly. But now this is more professional, I suppose. The nuts and bolts of agreements. Next. Oh, there it is. Okay, next one, please. So you can't read this, but we can kind of talk through exactly what these mean and some of the words, and then you'll have access to these materials afterwards if you're interested in looking at the actual language. This is an excerpt from CSU's standard section on intellectual property research agreement template. And what I would consider to be a very kind of under the law, but also a good starting point from something everyone understands about intellectual property is if I work on something and create intellectual property, I own it. If Bill works on something and creates intellectual property, he owns it. And if we do it together, we own it together in equal shares, both with the full opportunity to use it however we want. And so that is the beginning, the starting point for what we do at the university when we work with a sponsor. Once you have that ownership and you've created it, then the next set of negotiations and understandings is who's allowed to use it. So if I own intellectual property, Bill may want to use it. And so I still want to own it, but I want to give him the right to use it, but I don't want to give you or you the right to use it. So I'm licensing it for his use. And so when we work on a project together, usually the industry sponsor will want to be able to do whatever they want with the IP that's created by the university. And that goes, if you go back to the mission, that's not why we are in business. We're not in business to make money, but we're not in business to lose money. So, we have to do what's fair. And our starting point at this point with intellectual property, and it's different at different schools and institutions. And that's a whole other discussion that's very interesting philosophy from different places about IP, is that if the university creates IP on its own, so I'm the university, you have to be the industry sponsor.
I'm industry.
Your industry, sorry. I'm a grant after all, not a,
Not a
never
bill.
mind. That's terrible. So if the university creates IP with the money from the sponsor, that the sponsor should be able to use it. And a standard license is a non-exclusive royalty-free license, meaning you can do whatever you want with it. But it doesn't mean you can let someone else use it or that you can commercialize it necessarily. So we provide a sponsor automatically with a non-exclusive royalty-free license called a NERF for Bill to use it however he wants to internally within his company. And then we allow it to be commercialized, so put into his products and then used in a commercial setting. But it's not allowed to be sub-licensed. So Bill can't turn around and then allow another entity to use our technology. That entity would have to come to us to get a license of its own. Or Bill would have to work with us to get a license to give that license to another company they're working with to incorporate it into their product. Some schools don't do that. Some institutions, you only get that NERF for internal use only. That's the purest form of what we would think fits the mission of the university. But there's a spectrum, and this is where CSU starts.
It's important for us to try to start at that point because of all of the problems that I went over earlier, right? We want to try to get so that we're fully getting to our mission as a public university.
As close as we can. All it gets worse from here. So this is an agreement with Lockheed Martin. And so particularly if you're thinking about engineering, aerospace, and huge companies, they're very difficult to work with. And if they want to sponsor research, they want to. So this is an example of maybe some of the tougher terms that we have to deal with and come up with a solution for. In these red boxes, you don't have to read it, but it'll be there if you want to see it. So Lockheed still lets us use anything that we've created or keep anything we've created. But the kind of license they want is everything. We want to be able to use it. We want to be able to sell it. We want to put it in our products. We want to be able to sub-license it to somebody else. So the only thing CSU really gets out of that is to be able to use it on our own as well. And they can pretty much do anything they want. And when you're negotiating through these things, you may work backwards to the point where it's a make or break from the project. And so then we get into that concept of what is the project, how likely is there to be intellectual property, what type of intellectual property, and it doesn't need background intellectual property that already exists that the company owns that would make it harder for CSU to use it or to utilize it. So then it becomes case by case, but this is not what we want. Sometimes you have to get there.
So why would we not want this since it's non-exclusive?
So, and this is a bit of a tangent, but Strata, the replacement for CSU's tech transfer licensing group, anytime we share IP or share IP rights, they cannot turn around and exclusively license that IP to somebody else. So if a company wants to come use this IP and they want it to be just them that has the right to use it, they can't because we've given our sponsor that right. So it diminishes the value of that IP that CSU keeps or that goes to Strata. The second half of this is that background IP piece. So if our researcher has done A, B, C, and D from an intellectual property point of view, created it, done it at CSU, Strata manages it, or they've used it somewhere else and they've been using it in their research. Lockheed says, okay, well, if you're going to use, we want to not only be able to use all of your intellectual property, if we need to use any of your other previous intellectual property in order to use the new intellectual property, you have to give us that too. Or you have to let us negotiate for it. And this is really as far down the line as we want to get. It's as close as you can get to just doing work as a work for hire, where you get paid and all the results go to whoever sponsored the work. But this is about as far down the road as you would get, and you want to be in a discussion point of, can the research go forward at this point before you agree to things like this.
This would be pretty much totally private benefit, basically. Work made for hire, private benefit, mean the same thing, basically.
Right. So in this case, it's not good, but it's not as bad. So the IP created under the project still has the same concept as we said right at the beginning. If I make it, I own it. Bill makes it, he owns it. We do it together, we both own it. But we grant automatically the license, the rights in our IP to, this is also Lockheed Martin, isn't it? I forget what the RMS, it's a different part of Lockheed Martin.
Sikorsky.
Sikorsky, that's right. So we're giving them the right to do pretty much anything they want with the universe, with that IP exclusively for 10 years. So we can't license it to anybody else, no one else can use it. And then at the end of that 10-year period, it's a non-exclusive license, meaning CSU can turn around and use it commercially and license it commercially to someone else. So for this particular situation, it's again a conversation about what is the project, how important is it, what kind of IP might be generated, how useful is that IP. So for this particular scope of work, it's okay. We wouldn't do this in a lot of other situations.
There was a conversation that we and OSP had with PI about what this scope of work is, whether there was likely to be any new IP coming out, whether there was any background IP that would need to be licensed to them. So lots of things that have to come into play and decisions be made to know whether we move forward.
This is an example that, again, all these, one of the takeaways from all of this is that it really depends on the project and the scope of work. And we don't have a lot of time collectively to work on these things, but working backwards from that scope can really inform the, when you're really in the weeds on the details of things like these kinds of terms. In this case, it starts to look bad at the beginning. Project results of this work lists all the definitions for that, our own, and transfer it to the sponsor. They get it, that's all. Nobody else has the right, except university may be able to publish based on that. But you have a caveat right below it that the technology that the university brings to the project and any improvements to it, we get to own. So it's kind of a compromise in that, if we're bringing our IP into the project and, we actually make an improvement on it, as opposed to letting the sponsor own that, the university gets to keep our narrow avenue of that improvements on that specific technology, whereas the sponsor gets everything else. But if you kind of boil it down, we have the right to publish with some caveats on intellectual property and confidentiality and data. And we keep our rights to the IP that we brought and improvements to the IP that we brought. So, so depending on the scope, this could be an acceptable compromise. But you can see how all these starting points and even just the structure of the language is totally different in each one of these. And so it's confusing when you go into a different template or a different set of information to really understand what the outcome will be, because it looks different every time. This one's a problem because it starts to look, at the beginning, this is the ownership of information given to the university by the sponsor or developed during the services. This is a research services agreement. Become the project records. So the outcome of everything, these project records. And normally we would say, okay, the sponsor owns those things and we get to publish on those. And it doesn't say anything here that you can't publish. But it also does say that those project records are also defined to be part of the confidential information of the sponsor as defined in the agreement. And the caveats to publication, we're not allowed to put in confidential information into the publication unless they approve it. So now you have a student who has everything they need to publish to move forward to have their thesis, and they can't do it because we can't prove the data. And
Because that's one little change.
Right.
Maybe.
The definition of definition. They might as well have just said you can't publish.
There is a question from the audience. How often do we just come to a standstill and aren't able to accept an award if the parties can't agree?
Usually the frequent is,
Very rare.
yeah.
It can take a long time to get to mutually agreeable terms, but in my years doing this, I've maybe seen one case where we didn't finally come to some agreement based on the scope of work and tweaking terms.
I had a PI actually walk away and say it's not worth it. A couple of different times.
Sometimes we have to advise them, based on what the project is. There's one I'm thinking of, Bill and I are working on. Saying, boy, you know, they want a lot for this, and I know you want this money to come in, but it's not that much money. And they're really asking for a lot for relative to how much the project is worth and how beneficial it is to you. So it's not that we're representing, we keep talking about the institution representing CSU, but we're really also looking after the PI and trying to make sure they understand, you know, the value of the proposition too, based on the sponsors.
Researchers get to share in the license revenue that comes in through strata. So it's in their benefit to make sure that we were able to protect their intellectual property and not just give it away, but
Or prevent them from working on it in the future
Yeah.
as openly as they need to.
that's as important as
Yeah.
the money that they might get
Right.
from licensing.
Okay, so on this one,
Whenever I look at this, Patricia.
what do we see that might be in here that might be great if it wasn't in here? Or what is missing? I don't see any PI salary. So that is problematic on that end. And then also that F&A is split out. This is not a burden budget. So we definitely, again, want to make sure that we include those burden budgets. And Jenny, on your question, I've had one in my time at CSU that we had to discontinue because they couldn't come to terms. It was on budget. Yep, no tuition. Any other costs that we see that are missing? Okay, I think we hit it.
I missed the tuition, Tricia.
Oh, wait, and the indirect costs need to make sure that they're based on total direct. So. Yep, all right. Thank you.
One note about that is it's really hard for us, you know, Tricia, Bill and I, when we try to negotiate these things, that information has been provided to the sponsor. Because then we're already working from behind because we have to say we can't give on this. You know, we're like, this is, so it seems like they're negotiating to do something when it really should just be our starting position of having a fully burdened budget. This is switching a little bit away from IP is just some of the legal terms and agreements that are always a problem that we have to try to address with the sponsor who often, for business reasons and legal reasons, doesn't want to do it. Governing law and jurisdiction is an agreement between the two parties about how we will handle a dispute that goes to court. And you can agree in that contract, even if one party breaches the contract, and actually that's why you're going to court, that you've agreed in advance that this is how we'll handle that dispute. And the two things you often agree upon in an agreement are the governing law and the venue or jurisdiction of the action. So one of the philosophical purposes of the contract is to reduce the ambiguity of every possible scenario that happens between the parties. So at least in this case, we say, okay, well, we know where we're going to have a lawsuit and we know which law will apply to it. So the location matters a lot because in Colorado as a state entity, the Attorney General's office technically represents us in most things, unless it's something specialized or we petition the Board of Governors to allow us to hire a private law firm. So if you're the Attorney General of Colorado, you know Colorado law, and you're located in Colorado and you litigate in Colorado. So if we agree to have a court case in a venue heard in a different state, now we have to hire someone in that state who works in that state to go represent us there, and we don't have money. So that's one thing that we can negotiate away, or we can be silent on. There's a whole implication of being silent about civil jurisdiction based on business things and minimum contacts and the nature of the agreement. You don't have to go into that, but being silent is okay. Here, if you agree to laws, the venue in the state of Delaware, then we're gonna have to go out there. If we need to go chase the company for something, it's gonna be expensive for us to do it, and we'll be less likely to recover what this University of the State is owed. And if they sue us, now we gotta go out there and pay for that. And often you'll see New York, California, Delaware are the most common because they are the most universally utilized for big business in particular. Yeah.
Tricia can speak to South African tax or whatever that one was that we had. Dr. Bowen had somebody that wanted to do their South African tax laws for a proposal. He said no.
Yeah, we had to, and then anything like that, we try to negotiate out. Because it does come down to the, like Grant said, the cost. Like, how do we enforce it?
Do you have another question probably geared towards Tricia? What red flags should we be looking for at proposal stage?
I would say terms and conditions. Some industry sponsors want to negotiate it up front. And even if you submit through their portal, you're agreeing to their terms and conditions, is that we need to know what they are to know where we're starting. That's one. Also just clear communication and looping OSP in early so that we know what's going on if it's a sensitive sponsor and we can get started early, because sometimes these can take quite some time. I just had one that I've sent to the account text for setup and I got it in April. And I sent it yesterday. I was actually quite excited when I sent it. So yeah, it just sometimes it can just take forever, and the earlier we're involved and the more we're involved, the easier it can be.
That helps sponsors too, because even if we haven't agreed to some terms that we eventually will not agree to, they think we have, because we haven't brought it up yet, and we're getting down the road, it's harder to work backwards for that. And it seems like you've given something up when you haven't, but it feels that way to them. The last part on this is I mentioned the venue for a lawsuit, but also the law you apply. So the case law in different states operates a little differently on the civil side. It's a non-criminal law, and they interpret different business parts of a contract or the way it's defined for the law to apply to it. There are different laws passed in that state that affect the way things are handled. So you can actually use the laws of a different state in a court case in a second state. So we could have a court case in Colorado, but if we've agreed to the laws of Delaware applying to the interpretation of that contract, then you have a court case in Colorado with lawyers who either don't know Delaware law, or you got to go find someone who knows Delaware law and pay for them to come litigate in front of a Colorado judge applying Delaware law. So that's expensive. It's not good for anybody, but it's another thing that we don't want to agree to some other jurisdiction unless it's a process of its own. We have a general counsel or someone from our office to work it through and see if there's business value to doing it. LMC, Keith Martin.
Keep Martin again.
I know. A release of liability often seems intuitively like you're saying, okay, well, even if something goes wrong, I'm not going to sue you. I release you from any liability you might have to me, but it's often coupled with an indemnity. So it's not a release of liability from me going after Bill. It's a release of Bill's liability to everybody else because I'm protecting Bill. So when you indemnify another party, there are lots of different ways to do it, but a standard indemnity and a hold harmless and defend means that not only is Bill, I'm releasing Bill's liability to me, but also if Bill does something to a third party that's either related to the project or related to his conduct that's non-negligent, then I have to go defend him in court and pay for any damages that are assessed against him by that third party. There are some times it makes a lot of sense to do that when people are coming onto your property to do something. There are different types of regular business interactions where it makes sense to indemnify another party because they can't control a lot of the things that might happen to them. things like that. But in a research context, it's not appropriate. And CSU is actually prohibited from doing it in most cases. So we have to work this kind of negotiation out. And it's a broken record. We say it all the time. But there's a process that has to go up through the president's office to actually be approved to indemnify another party. It's not a guarantee that you'll get it, and it'll take forever. So we try to remind them of that. I think the last one of the examples is export control. So the first thing I did at CSU 10 years ago when I got here was work on export control. And we didn't have a policy or a procedure or an office for it yet because it was relatively new on a regulatory side for universities. It just kind of come to the fore and suddenly I said, well, we should probably do something about this. Overall, the export control purpose is to take sensitive technology, materials and information. They're not classified, they're not military things, but they are useful or dangerous. And so the federal government through Commerce, State Department, and the Treasury have regulations around based on what kind of information it is, how sensitive it is, who has access to it legally and who is prohibited from having access to it. Universities have a nice big carve out for our research so that we don't have to figure out if it's export control at a certain level. We don't have to figure out who's working on it in these ways, and we don't have to protect it and cordon it off as long as we're doing fundamental research. And I think that came out of the Defense Department, or State. Defense. And so we've been operating under that for a long time, but you lose that exemption of fundamental research in a couple of different cases. So what's the most common one you see? Foreign national
Publication restriction
publication restriction.
or a foreign national restriction.
Right. Those are the two main ones, probably.
Yeah.
So if we're not allowed to publish, like strictly not allowed to publish, now we're not doing fundamental research. We're doing, it looks more like work for hire. It looks like something that doesn't fit our mission. And so from the federal government's point of view, it's like, well, that's not fundamental research anymore. Maybe it's applied research, maybe it's just work for hire. So then you have to go back to the project and apply these different sets of federal regulations to decide if that technology is controlled by any of those regulations. And if it is, then you have to put safeguards in place and you have to follow the requirements of those regulations to protect the information. And we're not set up well to do that. It's very difficult to do and we don't want to. So we look for publication restrictions in all our agreements and try to negotiate those out. The second half of that that we see a lot are foreign national restrictions. I don't know why, as a matter of course, foreign national restrictions take it out of fundamental research, except it would be you're preventing. Why do you think that takes it out of fundamental research?
I've always assumed it was because that foreign national if no foreign national can work on the project, it means that the data is likely export controlled. There's no guarantee that it's export controlled, but if they say you can't have anybody from who's not a US person working on the project, it automatically takes away the fundamental research exemption because of the who could work on it.
Right.
Only US people can work on it.
And a lot of times that'll come as flow through from a federal award, maybe in a defense related award. Or it'll come through like an aerospace company. They're saying, we know the stuff we're working on is export controlled, or we think it is. So we're gonna go ahead and put this restriction in no matter what. Therefore, we have to treat it as commercially export controlled information and have a plan for how we're gonna protect it and who's gonna have access to it, all those things. And we try to avoid that at all costs, particularly when it's not appropriate. If it's not actually export controlled, we have to treat it that way, then it's a lot of administrative burden that gets in the way of the research that we shouldn't have to do. So we try
The
to.
company may be working on a technology that's export control.
Yeah.
But our piece of it may still be fundamental unless they flow or put this clause in the contract
Yeah.
with us. So we need to get involved early so that we can try to figure out, is it really export controlled? Is CSU getting or generating something that's export controlled? Or is the company just being overly cautious?
So if an industry is working, if it is federal flow through an industry, then we're not really looking at so much as an industry, all of the federal flow through park clauses and stuff is passing through, and that's what's. Do you see where I'm going? Because I can't quite figure out what I'm trying to say.
So if the company had a federal contract and we were a subcontractor on it, and their contract included export control language, which every federal contract is gonna include, frankly, we would still need to figure out, is CSU's work export control? The terms would be there because they have to flow them to us. But the crux comes in is what we are doing export control.
Does that put our fundamental status at risk if we're doing it on a federal flow through? Because we're doing what the federal government wants
We
done.
would like to get put into the agreement that specific language saying CSU is not receiving or generating any export control information.
Because if you think about it from a contractual point of view, and there are certain FAR and DFAR clauses that specifically call out export control information, and you have to regulate it this way. So by contract, if it's federal flow through an industry partner and they're flowing that down, we're agreeing to treat any export control information that way. But if we don't have any and they promise not to give any to us, we've decided that then we don't need to take any precautions.
Yeah.
Okay.
Yeah, we like to get not just the language I said earlier about we're not getting or generating the export control information, but that the sponsor, if they're going to, if things change in the future and they're gonna give us something export controlled, they would have to tell us before they ship it to our PI in a
Right.
sealed envelope with however they're controlling that information. So
And I think that
export control laws apply whether or not the terms are in an agreement. We're bound by the export control law that exists anyway. So it gets tricky and hard for us to know whether a PI may be doing something that's export controlled, which is why CSU has an export control office and theoretically is visiting with labs where they very well may be working with a piece of equipment, for instance, that's export controlled just because it has certain capabilities. So that doesn't come into play in negotiating a contract, but it's important to keep in mind that export control law applies whether it's a term in a contract or not.
But I think one of the big takeaways is to let us know about it. Let Shannon Pipes and export, well, I should move to CLI, but Rich Wright know about it, and essentially we'll help take care of it from there. But if we don't know about it or find out too late, that's when it's really a problem, a bigger problem.
Can't remember if we decided this was me or you.
I don't know. I'll do the first three,
Okay.
because they look short. So our ideal terms, to get back to the, the Venn diagram that overlaps with our mission and what is still beneficial to industry, comes back to where if that industry sponsor knows that they will pay full price and pay our overhead, and they know that it's cheaper still to do it here than their own overhead, they will pay for all of the costs to do the work. That's a starting point, but it's really what we need and what we are always looking for. Publication is one of the main missions of the university, and it causes a lot of problems for individuals, from PIs, students, export control, everything when that's not possible. Then you start to ask, why are we doing this? And then the IP ownership terms need to at least allow the university and that PI to benefit from the research they're doing. And so, the company will want certain rights or they'll want certain joint ownership or whatever it is, and we can negotiate that. But we still need to make sure or strive to have the university ownership of that IP have value and be available for future use.
Number 4 is that those are the standard IP terms that are in that very first agreement that Grant showed you guys. I think it's important as well. Often we see scopes of work that come from PIs that are 2 sentences long or even just a paragraph long, which can be really problematic because it leaves a lot to interpretation and could set them up for this company saying, well, you PI didn't perform, you didn't meet the deliverables that we contracted with you to provide to us. because nobody was clear on exactly what was supposed to be due when, and how it was supposed to be submitted to them, in what format, all kinds of things like that. So the clearer the scope of work, the better.
And as part of that, sometimes the researcher and the sponsor they all agree offline, or they send information back and forth, this is what we're doing. They don't write all that into the scope of work, it's a short scope of work, then you can come back and argue about it, because it's not specific. I'm not saying that industry partners act in bad faith, but they don't always act in great faith. So you don't want to put yourself in a position where you're having to defend a prior understanding or misunderstanding.
A lot of times the PI will have agreed to that in a Zoom call, for instance, and we're none the wiser. We agree to all of those terms and conditions, and then it comes back that, oh, we didn't fulfill all of the things that they agreed to, so. I don't know that I've ever had one actually terminated for default by an industry sponsor, but we've had arguments over whether they're gonna pay or not.
Yes.
And then the last one doesn't subject the university to unknown risks, like requiring us to go into binding arbitration rather than being able to go to court. And then the laws and venue of another state. And it doesn't require us to indemnify or pay their attorney's fees.
Yeah, prevailing attorney's fees are the common commercial contract element, where if we go to court, whoever wins, the other side has to pay for the defense of the winning party. Because we shouldn't have had to go in the first place. We won, you have to, not only do you lose, you have to pay for the defense of ours that made you lose. And the state doesn't do that. We refuse to do that because we don't know how much it would cost. It costs a little or a lot, and we're not in control of the other party's attorneys. They can go find the most expensive attorneys, and we would end up paying for those.
All right, well, here I come back from the internet. The relationship between industry and PIs, that's what drives a lot of our sponsored agreements. And so we do recognize that PIs need to discuss projects with sponsors. As Grant and Bill were just speaking of a few minutes ago, is that many times they're working out a scope of work or the project invoice or an email prior to. And so we do know that that relationship is key, and that PI should definitely feel free to discuss any technical aspects of potential projects with their counterpart at the sponsor. But do loop us in when things start to get more contract agreement related. If there's any non-disclosure or confidentiality agreements in place or need to be put in place, definitely contact us. And that one just note to remember is that the PI is not able to commit the university to any terms. That is one of OSP's responsibilities, and that's when we negotiate the terms. So it can cause heartburn if a PI makes a promise that is a hard no for us, or something that we end up having to negotiate in great detail. So just a quick reminder on that one. And now I will pass it back to my partners in the room.
So let's do this one together, Bill, but on the heels of what Tricia said, it's important that the actual negotiations with industry be from sponsored programs in my office. And, we can send our templates in advance with the proposals. We can set expectations for the industry partner. I like to think of it as a catch and release kind of scenario. So if we know about a project that may be coming up, we will either know something about having worked with that partner before, or the industry, or other considerations. And we receive that information and say, yeah, I don't see any red flags here. You go through your normal process here, or we know that this might be a problem. We need to address it up front. And although I think there's a perception that by engaging us early, it will slow you down, it will save you time. So if you provide the information and answer these questions right up front, it will save you time down the road, and it will be easier on everybody.
And I think it's important that PIs are open and honest with their industry sponsors about how far they can go and when they need to bring us in, and start that conversation before they even finish the scope of work or the budget. If the sponsor is really saying, yeah, we want you to do this for us, let's all get together.
Tricia has her hand raised.
I was gonna say, I have a great example of that. Actually, Mara was one of Dr. Bowen's, is we negotiated and had the agreement ready to go. And all we were waiting on was the funding to the sponsors, federal pass-through. They got it. We were able to sign everything, and I had it to the account tech in probably 48 hours from when the sponsor received their funding. So, I mean, it really does help to involve us early.
And the question on background IP is important upfront too. I think one thing that we've talked about administratively is we don't know what the IP involved in a project is. We are just trying to figure out, we're trying to understand what's happening on this project. We don't know what goes into it in the past, but the researchers should. And so as part of that initial conversation, that has to be contemplated if they know right up front, so that we can approach the project from that point of view as well, not just a standard one-off brand new research project.
I'd like to ask one quick question. So if we do have, like working with Tricia, we had information ahead of time. I can't remember if it was an MTD or whatever they're called. But I send it to her. So really, as research administrators at the department level, we should be sending that information to our SRA. And then if it needs to come to Grant for looking at it or anything like that, they pass it on, correct? That's the right flow. We're not sending anything directly to Grant or
That is a
anything
good
like
flow.
that.
I don't know if there is a right flow.
Okay.
But that would be a good flow.
Okay,
You can always reach out to the SRA and we'll pull in Grant when we need to.
One last thing that comes up a lot is companies all seem to want a master agreement, or researchers want a master agreement, because if we're gonna do so many projects with this group, it's gonna be great. We want it to be fast. We're gonna put a master agreement together and shoot out task orders underneath it, and then you do one, it never happens again. So it's not always a time when you would want a master agreement. And the flip side of that, this going along with that, is that one set of terms, all the terms that we ran through in those examples, may not apply to different types of work that would happen with that company. So you could come from different parts of the university, you could have different departments doing just different stuff. Some you'd want more IP protection, others it's not as important. Or even within one set of PI work, there could be some that's more testing related and some that's more basic and different flavors of research. So sometimes that makes it harder to do a master than to just do one. So it really depends on larger circumstance.
That's it. Here. Unless there are any other questions, we're 3 minutes over.
there's no questions in chat. Are there any questions in the room?
Just
So,
final parting shot is that all the presentations today will be, have been recorded, and we'll have them on the website soon-ish. They have to be edited, et cetera, so, but in the near future, they'll be there.
Tricia or Shannon, can you guys please put the link back out for the survey in the chat?
Tricia, can you help out? I don't have access.
I think she did one earlier.
Yeah. And we appreciate everyone attending today. I hope it's been great information for everybody, and appreciate all the help from everybody and our presenters, so.
Thank you.
Thank you.
Thank you very much. Thank you, Tricia.
Thanks for having me, guys.
Any questions, shoot it to these three, because industry stuff, like that's where it should go.
Don't hesitate.
Don't have.
Thank you.
Thank you.
Thank you.